Good morning, ladies and gentlemen. My name is Stella Wangoi Muragori. I am going to guide you through this particular process. Thank you for taking your time. Just dealing with that. Thank you for taking your time to join us on this particular day where we will be handling workplace disciplinary matters. Now, before I take you through an overview of what it is that we're discussing, it is important that I introduce the speakers first. There is myself as a managing partner of MMW Advocates LLP. I am a practitioner of employment matters, and that is prior to matters even going to the dispute stage. How do we ensure that we have a good foundation? How do we actually help you to ensure that you provide the right environment so that then mistakes that have been learned by other organizations in the past are not going to also be repeated mistakes by you? And I believe that is what case law is to ensure that we do not have repeated mistakes. And then similarly to that, I have Moffat, who is also counsel in employment relation matters. Moffat will introduce himself, and then followed by Jane Mutisia, who is a HR practitioner, and she will equally introduce herself. Thank you. Moffat, over to you, and then thereafter, Jane.
Good morning, everyone. My name is Moffat Atancha. I'm an associate advocate at MMW Advocates LLP. I'm also part of the employment department team, which deals majorly with employment labor-related issues. And I welcome you all to this particular webinar.
Jane, over to you. Seems Jane may not have joined, but we will sort that out. Very well. Jane Mutisia is the Managing Director of Career Management Center. She is also a well-known and renowned HR practitioner. We have actually handled a lot of HR matters jointly. And it was very important for us to have this discussion jointly because ordinarily sessions such as this would be handled by lawyers only. But then we get to fail to understand and see the other side, the HR side. As a HR practitioner, how do we condense the law in a manner that you would actually understand? And that is the conversation we're having today. To the next slide. It is always important to understand the firm that you are dealing with. So I will go through this very meticulously. Like I stated, we intend not to just have this as a lecture, but as a practical engagement, which is designed to equip you with clarity, with confidence, with control, so that by the end of the session, our goal is simple. You leave knowing what to expect, what to demand, and as a HR practitioner, as an employee, and similarly, perhaps even as a leader in your organization, you do know what it is that is expected of you. Before we dive in, the firm behind you is known as MMW Advocates LLP, one of Kenya's largest female-led law firms. Our vision is very simple, yet extremely achievable, to be Africa's hub for innovative solutions. Our mantra, which is what we live by every day, is embracing and solving the complex. Our service offerings spans full cycle when it comes to contracts. We do have the dispute resolution department, which is basically the department that deals with negotiation, mediation, court-related matters. We have the employment relations department. Basically, this is a department that focuses purely on employee-employer relations. We're talking about mutual separations agreement. We're talking about issues to do with policies, SOPs, trainings for such as this ones, and court-related matters, legal opinion and advisory work. We do have an environmental, social and governance department, a tax department, an intellectual property department, a real estate, corporate and commercial department. Now, our standing in the society has not gone unrecognized, and perhaps this should give you confidence that the team that is presenting to you is not only one that believes in self, but the society and industry has actually acknowledged it. To that end, we have one winner in the field of litigation category, particularly because of our contribution to this particular sector. That's the employment cases. Banking and Finance Law Firm of the Year in 2025. And in 2024, we won SME Law Firm of the Year in 2024. I can see someone saying that they're not seeing the slides. I'm sorry? Okay, good. Let us go to the next slide. Jane, if you're with us, please let me know.
Good morning, Stella. Yes, I'm very much here with you. My name is Jane Mtisia. I'm a HR practitioner. I lead Career Management Center, and also what we provide is ensuring that organizations are proactive in putting their HR governance systems in place to ensure you do not get in trouble, because trouble starts at the workplace before you go to the court. Back to you, Stella. Back to you, Stella.
Fantastic. Thank you so much. So now let us start this exciting conversation. When I was having a conversation with my team on disciplinary matters, one thing occurred to me. Previously, people would be focused merely on process. And historically, disciplinary hearings were merely a procedural checkbox. As long as an employee had been called for a disciplinary hearing, minutes had been issued, and the courts were satisfied that there was procedural fairness. In that case, not procedural fairness in terms of the depth of it, but a disciplinary hearing had occurred. It was deemed to have passed the test. But to be quite honest, ladies and gentlemen, jurisprudence is shifting, and we are seeing the Employment and Labor Relations Court now interrogating the integrity of disciplinary hearings. The court is asking, besides there being this process known as disciplinary hearing, was it fair? Was it lawful? And that is the question that we are asking ourselves, so that then we move away from the process of saying we have checkboxes, that yes, we issued a notice to show cause, they responded, they came in, had a 5-minute conversation, there was a predetermined outcome, and we moved on. The court is saying, hold on, we now want to lift the veil. Was it procedurally and substantively fair? So it is no longer that you did it, it is how you do it. And that is what the court is asking. And that's the conversation we are having today. So that then at the end of the day, disciplinary hearings can withstand scrutiny from courts and meet the fair and lawful threshold. So that is what you will gain at the end of this session. So that then we move away from practitioners who just tick boxes to those sort of practitioners who have a deeper understanding. Now, what is disciplinary hearing? Jane is going to take us through this particular slide and session, so then she can actually flesh it out for us. Jane, over to you. Jane?
Okay, so it's a formal structured procedure addressing employee misconduct contract breaches and hearings, and is conducted by disciplinary is given a chance, and the labor laws allows it's a right that the employee, nobody can actually be judged without a hearing. It's a right. So even if they have a violence, you must invite them to come for a hearing for them to be able to show cause why they should not terminate. For them to understand and explain the allegation that are put against them and put a defense so that they are without a hearing. The same thing that we do in courts. If a policeman arrests you with a traffic offense or whichever other offense, they cannot take you straight one of them. During the hearing, the employee must be given a statement of the allegations in advance. You must have a policy that says very clearly how many days do we give an employee after you give them the statement of charges, or they did this, they did this, they did this.
Jane, I think your internet is buffering. I believe your internet is buffering. So we can't hear you quite clearly.
Able to have a hearing that is very fair. Yeah. So the law talks about including the employee coming with a witness. So the nitty-gritties of what happens if they do not come with a witness. What happens if they come with a witness who is a lawyer? So all those nitty-gritties are things that you must be able to appreciate from a HR perspective if you do not want to be said you had a sham for a hearing. Back to you, Stella.
Fantastic. So I hope we have understood the key takeaway is, besides having a disciplinary committee, I'm seeing someone is saying we are breaking. Oh, that is translated to Jane. Jane, the team that's listening to us is stating that your internet was buffering and I could hear it from my end. So they did not get it clearly. So please, for the next slides, let us have your internet. So then we can actually have the team gain the insights that you are actually stating. But one of the key takeaways she stated is that disciplinary hearings, like I stated earlier, should not be a mere sham. So besides having a disciplinary committee, the conversation we're going to have is who should be there? What are some of the things that should be done before you set up this committee? What are some of the things that should be issued to the employee before you call them for disciplinary hearing? And who should be members of this committee? How should they actually show up? How should the investigations be done? Should a report be issued to the employee, assuming there's an investigation report? But the bigger question that we have today as well is that there has been a debate where people think disciplinary hearings are actually based on policy. Some people think it is just a favor they're doing to an employee. But we must ask ourselves, is it a creature of policy, or are disciplinary hearings a creature of the law? And that is the next slide that Moffat will take us through. Moffat, are disciplinary hearings a creature of the law?
Thank you, Stella, for that insight. And from James' definition of what a disciplinary process entails, it's important to note that this is a legally structured procedure whereby now employers must follow to address employee misconduct, poor performance, or mental incapacity. So it's then important to note going forward that this is a legally structured process that is provided for under the law. And now, noting that the Constitution of Kenya is the Supreme Court, supreme law of the land, it does provide for under Article 41 and Article 47. Article 41 gives every employee the right to fair labor practices. Then additionally, Article 47 provides for the right to fair administrative action, which now applies to this particular scenario. And now a discussion for the day on workplace disciplinary processes. In addition, the very parent statute that deals with matters employment in terms of now the disciplinary hearings and the processes involved is the Employment Act. The Employment Act basically provides for the minimum standards that the employer should adhere to prior to terminating an employee's services. Prior to terminating employee services on grounds of, now it does provide for grounds of poor performance, mental incapacity, also on grounds of misconduct. So yes, disciplinary proceedings are a creature of the law, and they have a legal backing in our statutes and in our supreme law. Then additionally, as Stella has highlighted, it's not majorly backed by policies of a given organization, but then the institutional instruments and policies supplement whatever the Employment Act provides for. And it's also important to note that the Employment Act does provide for the minimum requirements that an employer must adhere to while conducting this particular process. And it's also important to note that the disciplinary process as a whole is controlled by the employer. And that's why you've heard Stella mention about the aspect of how the disciplinary panels are being instituted. And she has majorly laid focus on this particular process in terms of what the employer ought to conform to. So generally, as a point that we all need to make reference to is that the disciplinary process is a creature of the law. That's number one. Number two, noting that it's a process that is controlled by the employer ought to at least conform to the minimum requirements and standards that are set by the Employment Act. Then additionally, we will also see as the presentation goes by that jurisprudence and case law have also given guidelines on what a fair process looks like. Thank you, Stella. Over to you.
Thank you so much, Moffat, for that. So now we know that we can never argue with employees or vice versa, saying that it is an issue of policy. It is no longer an issue of policy that is disciplinary hearing. And I like what Moffat stated. The law only provides for the minimum. But even when you say you're going to only look at the Employment Act, there's a demand for you to also see what case law is saying in defining and adjusting what does a good disciplinary process look like. So going to the next slide, which is now what we want to actually unpack. Okay? What is a fair disciplinary process? And to put this simply, please go to the next slide. To make this pretty simple, let's go to the slide on fair disciplinary process.
It's the previous slide, the previous one.
Thank you for that, Pride. Okay, so to understand what fair disciplinary process looks like, I decided the same way the court looks at substantive and procedural fairness. I similarly chose to actually, and because it is what the court is doing, I also then transposed the same measure and the same threshold to fair disciplinary process. It should be substantively fair, and substantively meaning the substance of it, the reason why the person has been called there must be fair. And then similarly, it must be procedurally fair. Procedurally basically means process, okay? So substantive fairness, what does that mean? And what are some of the ingredients you must tick off? There must be a valid reason when you call an employee for a disciplinary hearing. There is no other way around it. That is to say, validity of reason means that if an employee has done something wrong, it must be, number one, valid and clear to them on what it is that they did wrong. It must be against the law or against company policy, and not just mere machinations where an employee is actually targeted, so there's no validity of reason. Then there must also be evidence. So why are we actually having this employee being called for a disciplinary hearing? Is there actual evidence to support the validity of this reason? And the reason I say this is you cannot say that someone has, perhaps if it's coming drunk or coming late, are you able to actually support it? Or is it something that you're basing off feelings? And then proportionate action. Not every disciplinary hearing must lead to a termination. So was this something that should lead to a termination or should lead to a suspension or lead to a warning? So the court looks at the reason that was given for the disciplinary hearing versus the action that was meted out by that disciplinary committee. Are they actually proportionate? Do they measure in fairness? Okay. Must be notice. That is to say, I cannot call an employee for a disciplinary hearing tomorrow, because this is just a hearing like any other. And we heard about the rules of natural justice from Moffat. And natural justice, to be quite honest, just means that there is fairness. Fairness to be had, fairness and in terms of an opportunity to know what is being leveled against you, and even time for the employee to process what are the charges that are being leveled against me, And am I actually able to then process them, think about them? So notice is extremely relevant. Yes, the court may not say that, not even the courts. The Act does not say about 10 days or 7 days, does not give a definitive period. But it also must be fair. You cannot give within 24 hours, yet that particular employee still has their roles to undertake during the day. Just because an employee has a disciplinary issue does not make them any less of an employee. Okay? They must have the right to respond. So when you give them the notice to show cause, calling them for this hearing, because a clear notice period is demonstrated through your notice to show cause. Do you tell them at the bottom that they have the right to respond, or are they just expected to actually show up? Are you telling them that, please, within these 7 days, we expect you to actually give us a response as to why we should, or what your standard or stand opposition is as regards the reason that we are placing you before a disciplinary committee? And by the way, it's so important to state that not every issue must lead to a disciplinary hearing. If they are given the proper right to respond, and the committee sees that the response that is issued is actually valid and considered, then you may find that there's no reason to actually put this person through a disciplinary hearing, because it could actually be self-resolved. So you must give them a right to respond, and that right is in writing. Remember, this is a court of record. They only rely on writing. The court only relies on writing. Evidence is only produced in writing. So you cannot come later and say, we actually told him verbally. How do you prove it? Then the right to representation. This is actually provided in law, that an employee must be given the right to bring in a representative into the disciplinary hearing. And the rationale of legislators in this is to ensure that the hearing is conducted fairly, and assuming that a disciplinary hearing is almost in some ways adversarial, then the employee must feel that there's someone who is there, basically who is able to question the disciplinary committee and is able to ask questions to create a sense of biasness. It is also an issue of how is it perceived. It must be perceived in a manner that demonstrates there was fairness. And that is why there's a right to representation. And the notice to show cause must also state that you can come with a representative. Then fourth, impartial committee. The accuser or the person who is accusing this person cannot also be, for instance, the person who is actually making the determination on this particular person. So impartial committee means, I'll give an example. If an employee has been accused of stealing funds, and we will see a case such as that one, yet the people who he has been co-accused with, or the people who also serve in the same department, sit in that committee, are those committee members likely to be fair, or are they likely to also save their own skin? If you are co-accused with somebody else, or not even co-accused, but your offense follows a chain of events, that is, the person who is also approving the transaction I was doing is also a part of that committee, are they likely to throw me under the bus to save themselves? And is that a person who should be deemed as impartial? If they're not impartial, and that is going towards the forming of the committee members, then they should not be a part of that. And then finally, your defense must be considered as an employee, and as a disciplinary committee, you must consider their defense. So that even as you're writing your determination, even as you're writing your minutes, because part of procedural fairness is that it must be minuted. You must demonstrate that there was consideration of the defense, that every charge, every question, and every answer given by the employee, and every issue raised by the witness or the representative has actually been captured. One of the things that goes towards consideration of the defense is that once the minutes are done, you must give the employee the right to review them and to sign them. You do not want a situation where the employee states that they were not given the minutes, and then they are being produced at a hearing, yet they never had the opportunity to actually look at, was my defense actually considered? We have had situations where clients call us and tell us employees have refused to sign the minutes or have refused to acknowledge the minutes. Quite obviously, you cannot force an employee to sign the minutes, right? So in that case, what you can actually do is actually send it to them on email, give them a timeline and tell them kindly review. If within 7 days or within 3 days, you have not actually reviewed and signed this particular minute, we shall consider that you have acquiesced or have accepted the contents of those minutes. So I hope then that gives you clarity in terms of what procedural fairness and what what substantive and procedural fairness looks like. To the next slide. So we know now the broader picture and the granular issues. So what does workplace disciplinary procedure look like from start to finish? Jane, please take us through that.
Thank you, Stella. So we start with investigations. Again, not everything warrants an investigation. Some things might be just you give a show cause because it's there, but some things require investigation, and the investigation cannot be for an indefinite period of time. So it has to be something that is reasonable, like 2 weeks, 3 weeks. But we have seen cases whereby employees are sent away for investigation for a period that is indefinite. That will put you in trouble because you have to be reasonable and fair to the employee. So investigations, whatever you come out from those particular investigations, you must share with the employee if you're going to invite them now for the show cause, which is the next step. In the show cause letter, there are things that we see going wrong there. The tone of the letters. If you're going to write a letter that says that almost doesn't allege but concludes that the employee is guilty, again you get in trouble. So the wording of our show cause letters has to be very, very, very clear. Again, it's very important that you have a policy that backs up that is aligning with the law, that says how many days before someone can come for a hearing, because again we have seen cases whereby employees rush the process and becomes a risk. You give someone a show cause today in the morning, and they're supposed to respond by evening or tomorrow morning. The rush process says there was no fairness to the employee to prepare for a big decision that's going to make them maybe even lose their livelihood. So you need to have a policy from my HR perspective that defines the whole disciplinary process must be aligned with the labor laws in terms of, it says reasonable, but what is reasonable? So be very clear. If you say someone will be given 3 days or 4 days or 5 days to prepare a response, depending with the issue that is at hand, it's very clear that you must follow that particular process. So there, on a notice or to show cause letter, again, we'll always word it in a way that is not aggressive. You could be very sure they have done that particular offense, but the catch is if you word in a way that says they have no chance to come and defend themselves. So give the show cause letter, let them know the timing, let them know when this will happen, where will it be, and all those things. Remember, in the show cause letter, in addition to listing the allegation, you must also give them the right and the information that they should come with a witness. It's optional. If they are not coming with anyone, they should tell you. If they're coming with someone, they should also tell you, I'll be coming with so and so for ABCD. Sometimes they will not tell you, and your work is to manage the process without emotions. Your work as HR is to make sure that your management team is trained on how to have emotional discipline as they manage this particular process. So the day of the hearing, now we have the disciplinary hearing as the next procedure. When they come for that hearing, the tone of the disciplinary committee also determines a lot. When you have a committee that is very aggressive because they know this particular person has committed an offense, it affects how that particular process goes. And Stella talked about meetings, people refusing to sign minutes. To prevent that, you can also have an attendance register. So you have an attendance sheet where people sign even before you start the process. And it must be very well worded. We are meeting for the disciplinary hearing for Jane for this particular offense, who is attending, so and so, and people sign, including the employee that is attending and their witness. If they didn't bring a witness, that has to be minuted. If it's an online meeting, you have to mention people by name, just to confirm that in attendance to this particular hearing, we have Jane, we have XYZ, we have so and so, and we also confirm that Jane says she chose not to bring a witness. So very important that you have a process and people are trained in the process, because it is one thing to have an offense and to have a process, but even the process can be a sham. Stella spoke about the composition of the disciplinary committee. If the composition of the committee is not impartial, it doesn't matter that you had that particular hearing. It is going to collapse on impartiality grounds. So if the person that accused the employee is there in that particular hearing, if the investigator is there and actively getting involved in giving the verdict, again, it's going to collapse. So always go for a neutral committee where people can actually declare even before you start if they have any conflict of interest in that particular matter. Someone is already having a fight with the employee that you're about to fire, and it's the one chairing that particular committee, you will have the process, but the process is going to collapse if they go to court. Again, it's a court of documentation. Your documentation is what helps you win if you have to go to court. So always have this with the judge in mind. If your minutes are read, the questions that you're asking and the answers that are being written, if they are read out in a court, will you win or you need to look like you already had determined that this person has to go. So your language becomes very key. And even as you do the minutes for the hearing, do them in a way that it's the question, the answer, the question, the answer, like that, in a very simple way that they can actually see, confirm they were given the allegation in good time, and they're able to put a defense to that. As you plan your hearing, think about the whole process. Think about if they have to appeal, who do they appeal to? And have that in the structure already even before you start your hearing processes, just in case they appeal. Scholar, I lost your slide. You are not sharing. Stella?
I think you're experiencing a technical problem. We are sorting it out in a few.
Okay. Yeah, so then I'll just continue talking as you said that up. So talking about the committee. So don't have the investigator in that particular committee, have the process very separated. The investigation team, the team that is going to make the decision, the team that is going to appeal, that conflict of interest should be declared. Otherwise, if there's contamination in any of those composition of the systems, then there'll be a problem. Someone has just asked, do we say that they are going to be written in verbatim? You could write in verbatim. So put in a way that the employee is able to actually see what you discussed is what is being, if you're going to record again, state it even before you start that we are going to be recording this particular meeting and the minutes are going to be shared. If they refuse to sign, just tell them you can refuse to sign and give your reasons, or you can mark the things that you disagree with in these particular meetings, so that you're very clear in terms of what exactly could actually be able to go wrong. I always recommend that we have what we call the disciplinary committee governance checklist, which is you tick, do we have a complainant excluded from the committee, or you have in the committee that is making the judgment with the complainant there? Is the investigator excluded from the decision making, or are they there? They should be excluded. Is appeal body different? Yes. Have we defined the quorum? Are we having 2 people or only 1 person in that hearing committee? Or do we have a quorum of at least 3 or 5? What does your disciplinary policy say? Remember, if you do not have a policy, you remove the process from a structure to now making it depend on people. So if the person that is running the process is not clear, then you end up having it becoming a personal driven process. And that means you can actually get it very wrong. So it's always good to have a policy, because the policy now safeguards you. It becomes a governance process, and people don't determine who sits without unfairness. So very important. And then the conflicts and all that. If you do that, you reduce your risks in the particular process. We also have the composition in terms of who sits in the committee. For instance, you could be having a very junior employee, but it's a CEO, the senior most person that is sitting in that particular committee. Again, they might have been intimidated, and they can actually say they were intimidated in the process. Again, even in terms of the governance, in terms of making sure the hearing process is important, it's very key that you may ensure you're not just dealing with the offense and the process, but you're looking at the bigger picture of the things that are in your organization. Are documents coherent? We have seen cases in court whereby you find that maybe someone is being fired for absenteeism, but they actually clocked in. The day you are claiming they were absent, they actually clocked in. Or they have a different policy that says something different. So that coherence is very important. The process may not just focus on those 2 tunnel vision. It look at the bigger picture. So have your HR systems aligned, contracts, policies, and other documents speaking the same language, so that you do not have a contradiction that can actually cause trouble. I'm waiting for you, Mofa, to go to the slide that we're supposed to be talking about. I know there's one step that I've not covered. I think you went where the next one. Yeah. So decision making, again, I will talk about the risk of a rushed process. You meet right now, it could be something very small, but to be on the safe side, it's always important and good to give the committee time. You have discussed, you can see everything is clear, but just give yourself time so that you can make the decision maybe the following morning. It's not a legal requirement, but it helps to just show there was fairness and people have been given time to also reason and see for sure. Because remember, again, the purpose of the disciplinary process is not to fire. We are managing employees who we would like to retain, and we only have to fire if we really have to fire. So it's very important that you're sure the process is not just about the court, but it's a leadership, because the people who remain judge you with how you handle those particular cases. And then you have communication of the outcome. You write to the employee. You have to be very clear. And of course, remember that letter must go with a reminder that they can actually appeal that decision and put a timeline. You can appeal this within 7 days to this particular person. If you don't put a timeline, you risk them coming a year later, month later, when you have moved on, coming with an appeal, and it could be justified. So always put a timeline and have a section whereby they're actually signing that they have received the letter, to acknowledge. They don't have to agree with the content, but to acknowledge that they have actually received that particular letter. I think that's it. Back to you, Stella.
Wow, that was wonderful. So thank you for taking us through that particular process. So that then we actually bring it home. I want us to look at a very recent case, that is Kenya Union of Commercial Food and Allied Workers versus Thika Water and Sewerage Company Limited. So in this matter, because it was a matter that was brought out by the union against the company for the grievance, the allegation was that the employee was actually accused of financial mismanagement, right? And in this situation, we find that basically the grievance was actually someone who was in charge of finance, and they found that there was issues to do with how he was handling monthly bank reconciliation, payment vouchers for checks, and expenditures was questionable. As a matter of fact, some of the things that were raised by the managing director was that some checks had been double paid, and when he was asked about them, he was actually not able to actually properly respond. So what then the company did, or the organization did, is that they issued him a suspension letter and then directed him to actually hand over his role to someone who would be acting. And in the meanwhile, they decided to create or establish an investigation committee, because this is basically how do we handle investigations. Now, the committee comprised of a chairperson, secretary, and certain other people. But the committee included members who had a direct interest in the matter. And you remember I told you about if there's a chain of events where I am being accused, in this instance, of financial misappropriation, but the person who does all my approvals is part of the investigation committee, is that impartial? And that was the case that the court was actually facing and the facts that were before the court. So they did the investigation, and then now it all then proceeded to a disciplinary committee. Again, to compound the misstep, the disciplinary committee in this particular case had people who were equal to him, which is not too bad, but they were not experts. So they're equal in terms of maybe being HODs, but they were not experts in the matter. So meaning they would not be actually people who could make a decision as regards whether there was financial impropriety. And then also there were junior members in the disciplinary committee. So when this matter went to court, the court was addressing three issues. One, the investigative process. Two, the documents or the investigation report. Was it actually issued? And three, the composition of the disciplinary committee. So in the investigative process, the court asked itself, how is it possible that investigations were actually undertaken against an employee, yet they were not included in that particular investigation report? What does included mean? That if the investigators saw that there would be negative or adverse findings against this employee, shouldn't they also have questioned the employee to find out their side of the story? So this is to say the court is asking, if you're appointing an investigator, are they looking at both sides of the story, or are they just gathering material that will be relevant to terminate this employee? So that is one of the courts that the issues that the court was answering, and the court responded and stated, or directed and stated, that the investigator must question both sides, hear both sides, and include both sides of the narrative in the investigation report, if there's going to be an investigation report. Two, if the disciplinary committee is going to actually rely on that investigation report, it must be provided to the affected employee. So what this means is it should be produced in the same way the disciplinary committee will rely on it. There was also a recent case where the court was stating that you cannot give an employee a redacted version of the investigation report, but give the employer or the committee the full version of the investigation report. Okay. Then further to that, in this particular instance, they actually gave the employee the investigation report after the disciplinary hearing. So then it was not of any relevance. Then at the disciplinary hearing stage, are you introducing new issues? And in this case, the court found that the issues that were raised in the notice to show cause and the issues that he was being asked to actually respond to at the disciplinary hearing were misaligned. So you cannot conduct disciplinary hearing by way of ambush. Okay, so anything that you expect the employee to respond on, even if you give, assuming you first issued a notice to show cause, and you might need to amend it to include new issues arising, it is better you amend it so that then the employee is given an opportunity to respond to those issues and also is aware what the disciplinary committee will be handling, than come and bring fresh issues at the point of the hearing. So you cannot give redacted reports. You cannot introduce new issues at the hearing stage. Neither can you exclude the employee that you're investigating from the investigation process. And then finally, the court looked at the composition of the committee. And it said that the fact that there were junior employees at the committee or people who may not have understood the financial implications of what he did, that is to say, are they actually able to say that there was financial imprudence, or are they just merely relying on that particular report? Also, is a composition including people who have a conflict of interest or are directly connected with the matter in question. So if there's a conflict of interest, for instance, there's a person in the team, in this particular team, who was actually aiming for the same role that that employee had. Of course, that's a conflict of interest. If I know that I was the one approving the transactions, as was in this case, then of course I will save myself and throw this particular employee under the boss. And because of these procedural flaws, the court found that there was a biased panel, lack of access of documents, shifting of allegation, lack of genuine, and remember we talked about procedural and substantive fairness. The court went on to find that the dismissal was actually invalid and the employee was awarded 2 million. So then this gives context in terms of what it is that we've been talking about. So then you're able to see that we're not saying it merely because it is good practice, but it is actually something that could actually end up costing your organization. The next slide is on the right to appeal. So Jane, is the right to appeal, so because I can see we're doing badly on time, is the right to appeal merely procedural? That is to say, is it a creature of the law? If I don't have it in my policy, will it affect my chances? Or can I just say I do not have a right to appeal as a ground in my organization?
I think it's something that we must have because then it makes the process fair also, because fairness is a requirement of the process. It makes the process fair and safeguards the whole process. It can also correct errors. Sometimes maybe the committee was not maybe very, very fair and all that. So a different for appealing changes the whole thing. So for me, I would say it's a minimum that we must have in our HR policies. Even the court structure has a court of appeal, So it's very important in our fairness system because it's not just about the offense and the procedure, but we must seem to be fair. We must be sure that the process is actually fair. So again, I'll just talk about the right to appeal. It's a minimum requirement that people appeal, give them timelines, and ensure the committee that is appealing, you're not appealing the same committee that made the previous decision. Back to you, Stella.
Fantastic. Thank you for that. So then we are going to the next issue. So when you go to court, who bears the burden of proof to demonstrate that the hearing was actually, the disciplinary committee, the hearing, the investigative process was fair? Is it the person who brings the claim to court Moffat, that is the employee, or is it the employer? So then we understand the importance of actually minuting, of reporting, and of evidence.
Thank you, Stella, for that. Just maybe to add on what Jane has just addressed on the issue of the right to appeal, it's also important to note that it's best practice that an employer informs the employee of their right to appeal their decision in case that they make a determination to terminate the particular employment. And it's also evident in very many court cases whereby the courts have frowned upon employers who have failed to inform the employees of their right to appeal. And now this speaks to procedural fairness and substantive fairness as a whole. Then now on the aspect of burden of proof, we had earlier stated that this particular process is controlled by the employer. And as such, the Employment Act actually places the burden of proof with the employer. So it's then upon the employer to actually prove to the court. Remember, this process is subject to scrutiny by the court. So it's then upon the employer to dispense this particular burden. And from this particular case that is on our slides, which is Pius Machafu versus Lavington Security Guards, in this particular case, the claimant alleged that he had been orally terminated from employment and that there was no procedure that was actually followed by the employer. This is a clear case whereby the employer successfully dispensed this particular burden of proof as he provided evidence before court that he actually followed due process in terminating the employee who had deserted his duties. The claimant was a security officer in this particular case. Then that now shows you the importance of an employer dispensing this particular burden, because in a case where the employee goes to court and alleges that he was orally terminated, then it's not again upon the employee to actually prove that this particular process followed. The burden of proof will always rest with the employer. So then it's important that you note that as Jen had also highlighted the importance of documenting this process, in that when it stands now the test of law, you're able to prove to the courts that the actual process was followed and that the process was procedurally fair and substantively fair as well. Thank you, Stella. Yes, then additionally, on the aspect of compulsory leave pending investigation, the disciplinary hearing as a whole, the disciplinary process as a whole, is a process that has always been under scrutiny by the courts. And the court has made numerous pronouncements on this particular process that the employer now ought to make much reliance on. For example, in this particular case, Thomas Kerongo versus James Omariba, they did approach the court through a petition. The petition was eventually dismissed by the court, but then the court also pronounced itself on the aspect of compulsory leave because it's not clearly provided for under the Employment Act on what tenets govern the employers in issuing this compulsory leave pending investigations to a disciplinary hearing. So in this particular case, Thomas Keronga and two others were they were allegedly involved in corruption claims, and the employer had them on compulsory leave for an indefinite period. Then they did approach the court that, so after they were placed on compulsory leave, disciplinary hearing was conducted and they were terminated from employment. They did approach the court stating that the compulsory leave that was issued to them by the employer was unlawful, noting that it was indefinite, and that noting that their terms of service were affected by the compulsory leave, noting that they were on half pay. The court had this to pronounce itself on compulsory leave. It stated that there is no particular law that bars an employer from having an employee go on compulsory leave pending investigations to a matter that is subject to a disciplinary hearing. Additionally, the court did highlight that compulsory leave ought to be, it ought to be like it's like a preliminary stage in terms of, it's not a permanent decision that is being made by the employer in terms of, you find circumstances whereby the leave is indefinite, and at times your terms of service are being affected. Maybe you are on half pay or you are not paid at all. So the court highlighted that the employer-employee relationship remains. That's first. Secondly, that your terms of service should not be affected by you being on compulsory leave. And as such, if an employer decides to put you on compulsory leave, then it should not affect your terms of service. Then additionally on the same, on the aspects of now the whole procedure as a whole, it's also important to note that the rules of natural justice do take preference in terms of the employer should conduct this process in good faith, and that in any case this process is under scrutiny by the courts, that it should be able to stand the test in terms of whether the procedure was fair and whether there was valid reason. Thank you. Stella, over to you.
Thank you so much, Moffat. Now, the next issue we are discussing is, is the court just looking at whether predeterminations had been made? Moffat was to take us through this particular background, but I can do it. In this particular issue, despite the fact that the court had already, the company had already issued a show cause and there was a hearing, the court already realized that there was a predetermination. And one of the things that we must ensure that we do not do as HR practitioners, as lawyers, when advising our clients, is to show that there's perception of predetermination. If a process, and I remember Moffat saying that there must be good faith. Good faith basically means there is genuine reasons. And in this particular case of Odima versus Maya Pride, the court actually was able to interrogate. And you remember at the beginning I said the role of the court these days is just not to check whether you have done a process. It's not a tick box anymore. And 5 years ago, as a matter of fact, I was discussing with the team, 5 years ago, it was not an issue, that the court would interrogate whether there was fairness in terms of a disciplinary hearing. But in this particular case, the court actually lifted the veil and stated, even if, yes, we issued a notice to show cause, there were minutes, there was a committee. Assuming even the committee was valid, was fair, it was given that investigation report. But it is barely just a veil to make it look like there was a process. However, there was a predetermination. Then that would actually be deemed as a disciplinary meeting that is actually trying to rubber stamp that particular dismissal. And when you're trying to rubber stamp a dismissal, the court will still state that it is actually unfair. And this is something that actually makes employers feel robbed of that particular. They somewhat feel robbed because they say we followed the process. But if there's a perception of already a dismissal, particularly if an employee did not have warning letters and so on and so forth, then the court will actually deem the process as unfair. Now, Moffat, in the event that is procedural unfairness, what are some of the remedies that the court would actually offer an employee?
So should the court make a determination that the termination was unfair, Section 49 of the Employment Act provides for different remedies for procedural unfairness. And these include, number one, a declaration that termination or summary dismissal was unfair. Number two is compensation, that is in terms of damages that the courts can award. Then lastly, it's on orders for reinstatement or re-engagement. It's important to note that these particular remedies, they are discretionary rather than. So then you are not able to have a bookmark on what the courts can issue generally in a case of unfair termination. So it's the court makes a determination based on a case-to-case basis in terms of how it exercises its jurisdiction. So then it's important to note that, number one, a court can make a declaration that the termination was unfair. Secondly, the court can award damages, and this is strictly discretional. Then lastly, the court can make an order for reinstatement.
Thank you so much, Moffat, for that. So now we know, we've seen cases where employees have been awarded millions tens of millions, if we look at even the KPMG case. So we must also understand that this is just not, again, I keep saying, you might cost the company purely because of the issue of procedural unfairness. Now, if then we look at it from that perspective, and this is for Jane, if how we handle disciplinary process can cost the organization in millions, how then can we make sure that we have CEOs who do not pressure HR people to actually undertake a process that is unfair? Or HR practitioners are able to protect the company. And even as we look at this particular issue, I would say procedural fairness, not just as a management tool or a management instrument, but also a strategic tool and a financial tool. Over to you, Jane.
Thank you, Stella. Yeah, for me, this merit process is not just about that we might be sued. Even if we are not sued, the employees that we're employing will always have a feel of how the environment is in the organization. That here, discipline is meant to punish people, is meant to do ABCD. And therefore, how do we as HR protect the organization, or as management protect the organization from these very expensive litigation issues? One of them is ensuring that your legal, I call the HR architecture, the governance framework. Your policies are anchored in law, and employees are trained, management is trained, the disciplinary committees are trained, and everything you do is anchored in a policy that is also anchored in law. Either better than the law, but as a minimum. As a minimum is provided in law. Remember, the law may not just be enough. The Employment Act may not just provide everything. We have so many case law files that maybe sometime you need you might need help to ensure that then you comply and keep changing policy to be updated. So very, very, very important that even leaders do not come to a disciplinary meeting just coming to fire people. Even how we word our policy, something like the following offenses will automatically lead to dismissal, removes the whole process from just being fair. We should say may lead to ABCD. So all those things we must understand as leaders, as HR. Our work is not to just ensure that we comply with the law, but the bigger impact of how people feel about the environment and the climate in our organization. The reason we see people choosing to resign instead of going through the process is because of how the leaders and the managers are approaching the process. And if there's no governance framework, people feel there's no fairness. And if they go to court, again, it fails again on the governance structures. You'll find that you have very many pieces that are failing. You had a good offense, you followed the process, but the judge still rules that it was not impartial, it was not fair, because again, there are very many aspects that cannot be cured by having an offense and having the process. There are small things that the judge will pick just because the organization was not well structured from that particular perspective. Back to you, Stella.
Thank you so much for that. I truly like it that we look at it not just as a procedure or a process or something that is written in policy. And even increasingly, we are going to see lawyers, legal opinions on HR issues, how HR is treated as an asset and not just an expense in organizations. So that then we can actually work towards, because we are now at the tail end of this particular presentation. We are at the tail end of this particular presentation. What are our key takeaways? Number one, at the very beginning, have a disciplinary policy. And if you do not know how to draft a disciplinary policy, always reach out to us, to Jane, to find out how does a disciplinary policy look like. You must have a disciplinary policy that is not copy-paste. And this is something that has landed a lot of organizations in trouble, because you copy-paste policies, you do not review disciplinary policies, you are not thinking of how the law is evolving. So the same disciplinary policy you had 10 years ago, where you're having the tick box and the check boxes, and people are just ticking it, auditors are just ticking it, cannot be insulated from the law or cannot be law agnostic. And law is just not the Employment Act, but keeping up with actually the provisions of the law in terms of case law. It's important to say that case law is what shapes the law. So if you're not alive to case law, so that you're able to see these particular issues, then now going forward, the call to action should be, what does our disciplinary policy currently state about the committee, about investigation reports, about how investigations should be conducted? Two, apply these policies consistently, but it's garbage in, garbage out. If you're applying the wrong policy, then you'll have the wrong outcome. If fairness is not the preamble of that particular policy, and preamble meaning the foundational statement and principle guiding that particular policy, then you're finding yourself again with these particular issues. So one of the call to action that I have to everyone here is, so long as you have a disciplinary policy, even if you're just an employee listening on behalf of your organization, then champion for a disciplinary policy that is consistent with the law and is applied. Document everything. The court has consistently said that it is a court of record. Hearsay, oral evidence that is not corroborated, conversations that were had verbally with employees that were not minuted, that they have not signed, and we have talked about this, ensuring that they are signed. And so long as you go to court and say, we did do an investigation, where's the report? We issued a notice to show cause, where is it? We gave them the right to representation. Has that been put in there? We gave them sufficient notice. Is that on the notice to show cause? In that situation, you can be certain if you fail to document, you're failing the organization and you're failing yourself. Then provide the employees with relevant documents. And to add on to this, it means that, like I stated in the earlier case, if there's going to be an investigation report, they should be included, they should be involved. If you know that disciplinary issues the committee might end up having, the composition of the disciplinary committee might be an issue, nothing stops you from saying that now when we are inviting you for the disciplinary hearing, these are the members. Nothing stops you from doing that. If the employee walks in and says, I have this disciplinary committee, from a reasonable perspective, because you see, if an employee says it's a sole proprietor and they say that the committee is unfair, then that is also putting the organization in a very unfair space, because then they can't bring outsiders for this purpose. But then you can always bring consultants, like HR consultants. But nonetheless, the composition of the disciplinary committee should be deemed as fair. They should be provided with all the documents, and you cannot start introducing new issues because you've seen the employee has handled the issues well. You start bringing new issues at the disciplinary committee, and then comply. Surely, after this training, the least you can do is actually comply with what the law provides. Okay, so to the next slide in conclusion. And this is something that Jane is passionate on. I will let her wind up on it. Jane? Jane, can you hear me? Very well, I'll handle the slide. And it's very simple. Disciplinary processes are meant to be objective. So if they are emotional, that is to say, there's conflict of interest, there are people who are being emotional at the hearing, then it is actually not objective. It is retaliatory. An employee did something and there was already a predetermined decision, then it is not fair. If it is targeted, then again, the law will actually upset it and say that it was unfair. So I'm hoping that you have all learned that despite the fact that you are undertaking this particular procedure, that fairness, both from a procedural end and the substantive end, it actually matters to the court. So feel free to reach out to your lawyer, to HR practitioners such as Jane, when you need guidance or in updating your particular disciplinary policy. When you have questions, always feel free to reach out, because some of the listeners in this room are either going through disciplinary hearings or are in the process of undertaking disciplinary hearings. Before you take any further step, have this particular foundation in mind and ask yourself, am I actually rushing through a process that is going to cost the organization tens of millions in the future? So now we are at the end and we have anyone with questions and answers. I note that the same have been placed in the chat. Jen, I tried to reach out to you. I'm hoping you're able to listen to us or to hear us. I'll start with the questions from the chat. There are quite a number, but if they are answered through the If they've been answered through the presentation because they were asked earlier, then we will actually then have to move on to another one. I want to start with the earlier speakers. Okay. The first question is, and I'll have this go to Moffat. Can an employee bring in a witness who is a lawyer and not within the organization? So can an employee bring an external lawyer?
Yes, Stella, an employee can bring in an independent person to accompany him to a disciplinary hearing. What best practice confirms is that an employee should be given that option to be accompanied by either a fellow employee or someone that he or she chooses to accompany him to the disciplinary hearing. So yes.
The second question is, Judith has asked, what if an employee refuses to respond? That is either to the notice to show cause, I assume, or the minutes. Then you can actually document that. And one of the things, and document even a failure of a process on the part of the employee. If they fail to respond, you can actually email or write to the employee and ensure they receive it. Because the issue I find with physical letters, it can always be stated that it was cooked or prepared artificially for purposes of this hearing. So also send an email so that then they actually receive it, saying that we gave you this opportunity to respond, you failed to. It doesn't stop the process. We gave you an opportunity to come for a disciplinary hearing, you failed to do so. So you must document that particular process, but it does not stop the process from actually ongoing. And we have seen this, a case I saw where a disciplinary hearing happened, despite the fact that the employee had been given several opportunities to actually appear before the committee. And they were actually then dismissed on account of insubordination. But because they failed to respond, and you actually leave it at that, you actually don't document that issue. Then when it actually goes to court, the court will ask you, how sure are we that you actually give them that opportunity? Like I said, you can't compel an employee to do something, but it is upon you to then ensure that you're documenting when there are failures on the part of the employee or when there's insubordination on the part of the employee. The unknown user has asked, is it right for performance policy to state that if an employee has had a disciplinary issue, that they're not eligible for bonus? Jane, do you want to take that up? Jane? Okay, I think we've lost Jane. So I can take that up. First, bonus is a discretionary issue. Bonus is not an entitlement, but also it depends on how you have put it in your policy. So bonus is what an employee is entitled to under the Employment Act is their salary, right? And also what we call as, your SHIF, your NSSF, and other statutory benefits that are there. Bonuses, allowances, commissions, potentially most of them are actually something that are meant to make the employment space more habitable for an employee. So if it is a matter of policy, yes, you can actually state that in the absence of good performance, then they are actually entitled to a particular percentage in so long as the disciplinary issue remains unresolved at the point of issuing the bonus. Okay. Then another user has asked, what if the issue under dispute is insubordination, which the line manager has reported, but you as a HR does not have the details, regardless of really asking so as to know what exactly to write on the show cause? Again, as a HR practitioner, your role is to be impartial. So everything will come to you. Just like think of yourself as an internal adjudicator of sorts. Everything will come to you. If it is not substantiated, then it is not your role to actually then start to write a notice to show cause that has no valid reason. One of the issues that we stated was that there must be a valid reason for there to be procedural fairness. So if an employee comes with that issue, ask them to demonstrate it, but it could also be something that is not demonstrable, like sexual harassment. But are there WhatsApp messages? Are there texts? Can you actually institute an investigation report or an investigation against this employee to just see, or even you yourself, can you actually then question and find out, is there actual harassment, insubordination, and so on and so forth? So the employee who has brought it to you does not feel like they were not heard, And the employee who is actually undertaking this insubordination does not think that they can get away with it. So you can actually go a step further and look for evidence as regards this particular issue. Please scan page. Oh, leave it there. So someone else, yes, said a lawyer can attend. Then Florence Ngui has asked, as we give employee the minutes to write, do we have to give them a recommendation or a warning, either a warning, a termination? Please guide. Florence, I'm not clear. First, minutes are not written by the employee who is who has charges leveled against them. It is written by an independent party within the organization. You have to give them a recommendation. A recommendation letter is not what the law requires, is a certificate of service, not a recommendation letter. So if you're going to then diminish the integrity of the organization by giving a recommendation letter that is false, then it is not something that you should undertake. The minimum requirement by the law is a certificate of service. If the employee has stolen from the organization, they cannot come and ask for a recommendation letter, but you can give it in line of what it is that actually led them to the termination. I'm curious to know, in the event that someone gets an email which requests for a written response, and no process is followed and a written email warning is given, is this allowable? Moffat, we can take that up.
So I think in this particular case, I'm assuming the email has been couched as a notice to show cause. And if it ticks the boxes in terms of allowing you to respond to the allegations against you, and also highlighting all the charges against you as an employee, then it does suffice as a proper notice. But then in terms of the procedure, you have to scrutinize the procedure in terms of whether there is fair reason and whether the actual process, which is now procedural fairness, has been put into consideration. So yes, it depends on the particular facts of case, but then an email can suffice as proper notice depending on how it's couched.
Okay. Question is, who selects the HR committee? Is it left to the discretion of the HR? I would say that it is a management that is meant to select the HR committee, because the HR person is meant to be neutral in this particular process. So you want a situation where the HR is neutral, so that when they're attending that particular hearing, they're not deemed to have selected people who side with them, but they also have been selected. Does this mean that the line manager who may be accusing the employee should not be involved in the committee? Yes. Because then it basically means that that particular line manager has a conflict of interest. They may have a desired outcome, and they are the accuser. A disciplinary committee Joy, no, that was by Joy. Ruth Ndegwa has asked, should a disciplinary hearing in the case of, can a disciplinary hearing happen online? Yes, it can happen online. We have handled disciplinary matters where they happen online, particularly for international organizations or organizations that work offline. So it can happen online, it can be recorded, and then minutes extracted from it, because we are now even. Jane, the question to you from Florence Ngui is, do you say that the minutes be written in verbatim or not reported speech? Okay. I can see Jane is trying to join. Can you admit her? Good.
Yeah.
Okay. Jane, can you hear me now? There was a question that was directed to you. Very well. So you can answer this question offered. Should it be verbatim or in reported speech?
I think it should be verbatim in terms of giving a clear picture of what the proceedings were and what the parties agreed, the determinations that are made therein.
Okay. I seem to have lost, yes. I can see the questions are quite a number. Diana Onditi, please let us know how much more time we have. Diana? Diane, sorry.
We have like another 15 minutes.
Okay, so we can still handle some of the questions. The disciplinary hearing minutes need to outline what the panel has agreed on and outcome agreed. During the hearing, at what point do we have the investigation team and the accuser at the disciplinary hearing, now that they don't sit at the hearing panel? Moffat, you can take that up.
In this particular case, so you see the investigation committee basically does the preliminary investigations, and they do furnish the committee with a report. This particular report should be availed to the employee so that it enables him to also respond to the particular allegations therein. So then, in this particular nexus, as at when the disciplinary hearing is being conducted, then the parties that should be in that particular hearing to comprise now the disciplinary committee, the particular employee that has been affected by the allegations, and maybe their representatives in that case.
Stella, you're muted. Stella, you're muted.
Oh, sorry.
Stella, you're muted.
The role of the investigator is merely to investigate. The role of the disciplinary committee is to adjudicate. So those two roles should not be conflated. So once the investigation team has finished the investigation, the role is to hand over that particular report, not to come in and then now use the report as a means of accusing the employee of the charges that are leveled against them. Then to the next question, because I've seen we then have taken up, can they attend the hearing? Yes, an investigator can attend the hearing because it is the report that actually led to the disciplinary hearing. And remember, we talked about substantive fairness in terms of validity of reason. So you find that the investigator actually then gave validity to why we conducted the investigation. Moffat wants to add something.
Just maybe to add to what Stella stated in regards to now the investigation committee attending the disciplinary hearing. Remember, the disciplinary process is being conducted just as a normal case in a judicial setting. So then the investigation committee ought to be part of the disciplinary process for purposes of being cross-examined by the employee, because you see it's a whole process on its own. So yes, they ought to be present.
If you're speaking, you're muted. Moffat, Stella.
Yes, so to clarify, the investigation committee do not serve the role of being adjudicators in this particular matter. But then noting that they do own the report, then they ought to be, the employee ought to be given an opportunity to cross-examine them on that particular report. Yes.
I think then that has been made
Maybe just
clear.
to add to that. Maybe just to add to it, the mistake we have seen is that the supervisor is the one reporting and sometimes the one chairing and even very active. They are reporting and they're sometimes the investigator, but then they are very active in the deliberations. Not serving as an investigator now anymore, but almost serving like the chair sometimes of the hearing committee. So that is a mistake we make. They can be there. They'll respond to questions if the employee wants to ask, can I get this? Can this be verified? But not for them to be the most active person of the committee. Back to you, Stella Moffat.
Thank you for that clarification. again, I've lost. I think when people type, it ends up just when people type, it ends up pushing certain presentations up. Let's see. Okay, I found where we are. Jane, a question you can answer. How many members are recommended in the panel? Is HR supposed to chair the committee? Jane, you can pick that up.
I would go for an odd number, but not a very big number for us to intimidate the person. So 3, 5 for me is okay. If you now go to the 7s, the 10s, I think that is a very big panel that can cause actual intimidation. So I would go maximum 5, just for the purpose of making the room doesn't feel too heavy on the person that is responding to the allegations. So it was the number of the panel, and what else? Stella?
And can the HR actually be the chair of the committee?
If you become the chair of the committee as HR, then a lot gets complicated. Opinion, I always tell the HR to be the person that is guiding the process. Try to be the neutral arbiter for both parties. That even the employee can later come to you and say, I feel this and this should have been done differently. Try to play the neutral arbiter that has not taken sides.
Okay.
Guide your team behind the scenes, let them be able to run with the process. Be in the room, but be a very neutral arbiter. Not because you can't, but just remain someone neutral that the employee can actually come to.
Then the next question is, and this is still to you, Jane. There seems to be different schools of thought. There's a school of thought where some people say that, yes, I can bring an external lawyer. And then there's a school of thought where employers say, no, the only person who can come in as a witness is a fellow employee. Jane, where do you fall on this particular one?
I know the Employment Act says you bring another employee to come as a witness. Most of our policies team, but I know there's a case law file that I can't remember where the judges said it is still representation, and have certain committees where an employee came with a lawyer and we still went ahead with the lawyer. The only thing that you have to take care of is do not let that turn to a litigation, almost like a court thing, conversations. The lawyer has to know that it's an internal process. Even if he's coming for the meeting, there is a way you define their scope in that particular aspect. One time we had such a case and the lawyer requested for 14 days. But the employee we're dealing with already knew what we're dealing with, and we had followed the disciplinary process. So the lawyer must know it's an internal process. Our policy says we give the employee 4 days, we give them 4 days, and therefore our hearing is today. So don't let the lawyer come and take over the process. If they come in, it's okay. If you refuse, the employee can actually say they were denied representation and a witness. So let it go. I know we have such a case. Stella, you could give more light on it, where someone actually came with a lawyer, they were denied. They went to court, they actually won. So I would still put in our policy, bring an employee because it's easier. But if they come with a lawyer, handle it and be very, very clear that it is not a court process. It's an internal process that will be run within the company policies.
Yes, actually, it's a case of Ratemo versus Kenya Film Commission, where the court stated that under the Act, it says that you can actually bring in a shop floor trade union representative who can actually come in to represent the employee. And they can be either a passive witness or an active witness or an active representative, depending on what it is that is required from them. So the court said if it is left to the employee to determine what role the two persons play, it is left for the employer and what the employee wants in terms of the role that this person's play. So that is, they can be passive or active. It depends on what the employee wants. However, the court went on to say that disciplinary proceedings are viewed as internal and labor relations exercise and should be shielded from incendiary effects of lawyers. So basically what the court was saying that the less lawyers are involved, the more likely it is presumed that the employment dispute will be resolved without necessarily escalating it into a full-blown legal issue. So the court was saying it does not see why a lawyer in certain circumstances should not be allowed to actively represent the employee because maybe they are complex matters. But on the other hand, if it is an issue that is extremely sensitive, that may involve issues to do with the organization's trade secrets. Quite obviously, you may find that you may not want such information leaked to outsiders. Or the court basically saying that, number one, it is okay to have it in your policy that it is an internal process. But the question the tribunal should ask itself, is there significance is there any significant prejudice that would actually happen if they brought in a legal representative? So then when they say, an employee says they want to bring in a legal representative, you must address that question from a point of what prejudice will be suffered, right? Then what is the appropriate format for preparing disciplinary hearing minutes? I think that has been answered. Who should be in the committee? That has been answered. Then Victor has asked, your opinion on person X employment history. Person X is employed under one contract in 2020, extended to 3 years in 2022, transferred to another branch, bears deductions for previous holders, again transferred to another branch, and is joined by a staff who shoplifts and billed all products in his account. The employee had requested for account adjustments, so he was able to credit over 20K. That employee X was dismissed for operational mismanagement, financial handling. What are the remedies? Moffat, take that up.
So, as I had earlier stated, the remedies are provided for under Section 49 of the Employment Act. So, based on these particular facts that have been displayed, the remedies, perhaps the employee can seek for compensation if the court makes a determination that the termination was unfair. Then the employee can pray for damages in terms of compensation, which is not entirely discretionary.
Perhaps I could add, because I've gotten an opportunity to also internalize the case. If the employee is being accused and terminated on account of previous mismanagement by previous employees, then that is indeed unfair. That is to say, I cannot come and, for instance, if I was a finance manager and I joined the organization in 2025, and then I'm being held accountable for things that were done by employees in 2024, or my previous boss, or I mean, my previous, the previous employee who was seated in that position in 2024, then that is unfair. And if you're terminated on account of that, that is unfair termination. And you can therefore seek the remedies in terms of damages. Is it fair to redact an investigation report? The court has said you cannot redact an investigation report. If you're going to use an investigation report to actually deem me as having committed a particular offense, then you cannot give me a partial report, but terminate me on the full report. Is cross-examination of witnesses mandatory? Yes. Because you remember, and it was in one of the cases that I actually referenced, Kenyan Union of Commercial Food and Allied Workers, where the court talked about it should actually, even from a perception perspective, the process must be perceived to be fair. In Kenyan Union of Commercial Food and Allied Workers, the process must be perceived to be fair. So if you're going to actually then say that I committed a particular offense, and I find that the information that is in the report is not actually adequate, I have a right to ask, when was this? How did it happen? What did you find? If it will help me then answer the questions before the committee in a fairer way, in a manner that actually allows me to understand what the issues leveled against me are. Current case law, it is assumed to just rubber stamp. Okay. Right to appeal. I think, Jane, you answered that. How do HR go about malice from senior management, where a senior manager says they want to clean up all staff and HR declines such stance? Jane, that is right up your alley. Pressure from senior management to clean up.
The question is, how do you go? The question
Jane,
is, how does
you?
HR go
Yes.
management? The question is, how does HR manage managers who are malicious?
Malicious or want to clean up? And then HR declines.
I always talk about HR knowing.
Yes.
I didn't hear the second question. But in terms of HR advising management, when we advise with emotion, like if you do this, you're going to be sued, and you don't do like the equivalent of what Stella and the other lawyers do, which is a legal opinion. So learn to use the case law files, develop legal opinions, and share with your bosses. So that it is not you saying, if you do this, you're going to do this. Share a written document that says, when you go to the legal, to the case law, to the Kenya law report, you'll find cases exactly as what you're dealing with. So most of the time, there are no new things in the world. You go there and find someone who's been fired because of ABCD, take 2 cases, show them how it ended. Trust you me, most of the time, when your boss can actually see how that happened, they see. sometimes training managers to understand how they get in trouble. Because I've seen companies that only now start taking HR seriously when they have been sued and have lost a lot of money. So my answer again, learn how to prepare legal opinions. I call them HR legal opinions that you share with your boss in a very summarized manner that they can actually see. If you go option A, this will be the outcome. If you go option B, there's a chance that you might be sued and pay 12 months pay. Then they start respecting not you, but the consequences of what might happen if they take that route.
Okay.
That's what I see. But every time you keep arguing with emotions, we don't do, it becomes a problem. Back to you, Stella.
I think one of the things that I would add on to that, Jane, is that HR practitioners should also partner with lawyers, right? Because even as, yes, you can say you can do your case law, but then you must understand that it is lawyers who hold the legal knowledge. And one of the practices that I've seen a lot of HR practitioners use their lawyers as an asset, where they say this is a situation, we would want an external, so there's a position of management and there's a position of HR. Then we are saying we want a legal opinion on whether if we did this, what the situation will be. Because in the event that that issue goes wrong, trust me, it is going to be the HR who will be, assuming there's even a change of management later, it is the HR's neck that will be on the line because they'll say, how did you allow this? So always seek an external opinion. If you can't, always do a memo internally that, yes, I'm willing to do this. However, my stand on this is that it is not fair, it is not right, it will cost the company, and so on and so forth. So that even similarly, you're also documenting the same, should it come up to be an issue against you. Okay, who is supposed to sign minutes? That has already been dealt with. An employee makes internal arrangements for the staff for December holidays for 22 million, then to resume. Okay. An employee makes a decision for employees to go on holiday on 22nd, 23rd, 24th, resume 27th, 28th, 28th, 29th, 30th to relieve the other staff. The employer comes to initiate disciplinary action. Is it justified? First, if that employee has not done this with either in line of policy, even if I'm an employee and I may want to send employees on leave, it has to be in line with policy. It has to be in line with approval from management, and it has to be also approved by management. So I cannot, as an employee, just make internal arrangements to the exclusion of policy and to the exclusion of HR and to the exclusion of management. Isn't the half pay bit during compulsory leave illegal? Moffat, you can take that.
So as I earlier stated on the aspect of compulsory leave, the law does not clearly pronounce itself on the aspect of compulsory leave, but then the courts have stated that an employer is not prohibited from sending an employee on compulsory leave where the circumstances warrant it, and provided that it's an interim measure. So in this particular case, if the courts do clear you as an employee of if the courts do clear you or the employer in this particular case prior to after the investigations that you are cleared, then you are entitled to the full pay.
Stella, you're muted. Stella, you're muted. Stella, you're muted. Stella, darling, you're muted.
Okay. If employee is given suspension, are they supposed to be paid? So if an employee, again, this is subject to policy. And I think that question has been fully answered by Moffat. Can we access the recording? Yes. Virginia has answered that. There was an instance where an employee billed his meal on the account of a client. It is a hotel setup. The employee didn't have prior similar cases. However, the employee was terminated. Was this just on account that he was trying to add his bill to the guest bill and the guest was to pay? That might be difficult for me to answer. Unknown user, could you just give us the full facts and circumstances? Virginia says that you can also find this presentation on YouTube. I know we are doing badly on time. Could you have management that does not respect laws, policies, HR, has done everything right, but there's just no support, and HR is treated as one that is just that is there to just defend employees. But you could have management that does not respect law, policies. HR has done everything right, but it's not just support. Okay, that's a statement. Victor has asked, can one resign after noting a fair process and still get compensation? Moffat, do you want to take that up?
And so once the disciplinary process has commenced, under the circumstances, it could be constructive dismissal, noting that the circumstances in which now the employer has subjected you to vary your terms of service with the employer. Then in that case, you can actually resign, and it can be deemed as constructive dismissal, which is now eventually an unfair termination in law.
Saying I'm attending a disciplinary today afternoon for absenteeism for 3 days. How should I approach it? I see so many flaws. I want to resign, or can I get someone to accompany me today? First, you should have been issued with a notice to show cause. This has all been answered. If you look at our slide on procedure, there must be a notice to show cause. You must be given the right to respond. You must be given the right to a representative. And also, you must be informed what it is that you're called for, so then you can actually respond. I would urge you to take a screenshot of this particular slide on work disciplinary procedure. Thank you for this, Ruth Sarem. Thank you so much also for appreciating. Catherine, in cases where an employee chooses to resign with immediate effect and the employer chooses not to pay them their monthly salary on grounds of that the employee did not give the required notice period, what does the law has, basically what does the law provide for this, Moffat?
So in this particular case, number one, it's dependent on what grounds the employee resigned, because you see if it amounts to constructive dismissal, then it is unfair termination. But then, not depending on the contract between the employer and the employee, if the contract provides that notice ought to be issued, then that's the term that governs now this particular relationship, that notice ought to be issued. But then if it's constructive dismissal, then it's unfair termination. So it depends on what grounds the employers designed.
Then someone is asking, are employers running away from disciplinary processes to a fixed term contract? I do not think when an employer gives you a fixed term contract, it's because they are running away from a disciplinary issue, because then you're assuming that you will actually have a disciplinary issue. That, I think that is an assumption. Perhaps do certain employers use it as a mitigating tool? Yes. But I wouldn't say that they're running away from disciplinary processes. Then, is it a requirement to have a HR practitioner? Jane has answered that question. Is the position really settled for an employee to be accompanied by an advocate? We have answered that question. For the disciplinary committee, and also on that question, remember, if you are refusing for the employee to come with a lawyer, you can actually state your reasons as to why. Is it an internal issue? Is it that you do not want it to be extremely adversarial? I'm being keen on time. What if, Jane, this is for you. What happens if an organization has very few employees? So how do you then compose a disciplinary committee where, let's say, an organization only has the senior employee and maybe there are just only 5 other senior people?
You can invite other people, and you can even put that in your policy. I have personally sat in disciplinary committees for as an external HR advisor. I'm very sure even Stella has supported organizations. So you just need to ensure that you comply with the law. So if it means you come to someone who understands the law, like MMW advocates or myself or any other person, you are allowed. The most important, fairness. And you do things within the law and with dignity. Back to Stella.
Okay, so standard composition, we've been told let us have an even or odd numbers. What happens when an employee receives a show cause, shreds it right before you, and fails to respond? Wow, Jane, do you want to pick that up?
Bring it again. Say it again.
What if an employee receives a show cause letter, shreds it, basically tears it into pieces right in front of you, and fails to respond?
Wow. If they did that to me, I would do an email to them just confirming that I gave them the show cause letter and I want to understand what they didn't agree with. Because sometimes some of these things are very emotional, Stella. And for the HR, we have to have what we call the emotional discipline. Don't overreact when they have done that, because it could be they are very shocked, or maybe the other issues. And I've seen us giving people show cause letter without having another meeting before the show cause. So it's always good you call the person before you give them the letter. Take them through what is happening. We have received this, we have not formed a judgment, but we want to hear your side of the story. What exactly happened? So then they know we are not condemning them, that they're already guilty. So sometimes I know we skip that process, and that's why some people resist what we are saying. One time we had a case of an employee who said they would not go through a PIP even if we did what, and they walked out of a meeting. So the most important thing, emotional discipline, be grounded, and then pursue. Ask them again and draft an email, just summoning the same or sending the same letter now on email for them to respond. Because either way, if they don't show up, then they sabotage themselves. And remember, for you, you have to protect yourself through documentation and showing that the process was equally followed. And he did not want to be heard. You didn't condemn them. It's just that they did not want to be heard, and it is them refusing to be heard. Back to Stella.
Very well. I've gotten an indication from the team that we only had 15 minutes. So we have passed, we're way past that. I would urge you, please use the code that is displayed, because unfortunately we are unable to take up all the questions that are there. We are now close to 2 hours in, meaning that there's such a huge appetite for knowledge as regards how to handle fair disciplinary processes. So I would ask you, please scan the code, use it as an opportunity to answer questions that you may have. On the previous slide, we have actually included our details, that then we can actually, because we understand today is a work day, so that we can release people to go and actually undertake their roles. We do not want this presentation also to be a ground as to why you did not perform, to be quite honest. So thank you so much, ladies and gentlemen, for giving MMW Advocates LLP and Career Management an opportunity to actually present on this. You have been an amazing audience. You have engaged us, you have interrogated what it is that we're presenting. We are more than happy to consistently partner with KNCCI or with the organizations as well, so then we can have internal trainings, particularly where you're seeing that your team, your leaders, your senior management are not doing the right things. Feel free to reach out to us. Remember, lawyers, HR practitioners, HR consultants are an asset to the organization. They are not a cost. I would rather you incur the cost of the lawyer at this point than the cost of embarrassment, depreciation of your reputation, damages, and you being a president. Please, as someone who has been part of this training, I would not hope to see your organization being used as precedent, where now we are saying in this organization, and yet you are part of the training. Okay? Thank you so much. Over to you, KNCCI. Diane, thank you so much for the opportunity. From the team of MMW, thank you, Moffat, to Virginia, Pride, Philip. Thank you so much also for being a part of this wonderful team. Dan, over to you.
Thank you so much. I'd like to take this opportunity to appreciate everyone who took their time to join the webinar. I'd like to appreciate the MMW team for actually taking us something that is very important for all employers and employees, and also to appreciate Jen. Thank you very much.